Good, good evening to all of you. We have finished up to section 211 of the Contracts Act. Today we go to section 212. Here, this speaks about the duty of the agent. The agent, when he conducts the business of agency, he has to act with skill and prudence, and then conduct it in a manner which is beneficial to that of the principal. And uh, here, normally it is presumed that any person who is appointed as an agent has got skill and experience, but unless the principal has notice on the, of want of skill. The question is, normally when the agent is appointed, the principal takes all precautions possible to appoint the correct person correct for the correct job, and then he also assesses the skill and experience of the agent, and it's also presumed that the agent will conduct the business to the best interest of the principal unless and until the principal has noticed that the agent does not possess the necessary skill and experience. 213 speaks about an agent is bound to render proper accounts to his principal on demand. See, after all, the law of agency or an agent is appointed on trust and confidence, yes, which the principal reposes in the agent. Whatever outstandings are received on account of the business of the principal by the agent, proper account books will have to be maintained, and whenever accounts are demanded from the principal, the agent will have to render proper accounts. That is what Section 213 says. Please remember, if these checks and balances are not there, then what would happen is we would have agents who are mostly fraudulent or who usurp the monies of the principal. That is the reason 213 says proper accounts will have to be maintained by the agent who is accountable to the principal, and at any time the principal may inspect the accounts or call upon the agent to furnish accounts and to render accounts for the collections which he has made in respect of the business of the principal. That's what section 213 speaks about. Then 214 speaks about uh, agent's duty to communicate with the principal, and cases of difficulty he uses all the reasonable diligence by communicating with this principal and seeking to obtain his instructions. Normally speaking, the principal knows much more than an agent. A scenario may arise when the agent is in difficulty, when he is not able to tackle a particular problem which comes about in the agency business. Then he should not feel shy, that he should communicate to the principal, sir, this is the difficulty which I'm having as far as the agency business is concerned. Please give me proper directions. Then, in that case, the principal gives the proper directions, and according to the directions given by the principal, as regards the difficulties experienced by the agent conducts the business. So, please remember, communication is very important between the principal and the agent, and the business has to be conducted in a transparent manner, and the agent should think that the business which is carrying on for and on behalf of the principal is his own business, and he has to exercise due diligence and act in a manner which is beneficial to that of the principal. And in cases of any difficulty, in cases of any problems, in cases of any questions that arise in the conduct of the agency business, the agent can communicate with the principal, seek his directions, and act according to the instructions of the principal as far as the problem on hand is concerned. Then, sir, 215 deals with if the agent deals on his own account with the business of the agency without authority and consent of the principal, and acqua- and acquainting him with all material circumstances which has come to his own knowledge on the subject, the principal may repudiate the transaction of the transaction, either that any material fact. Suppose, let us say, the agent has not been given the authority, but the agent acts contrary to the authority, does not inform the principal, but acts on his own and deals the business on his own without the knowledge of the principal. Then in that case, it gives an option to the principal to repudiate or terminate the agency and put an end to the duties of the agent once and for all. Then, sir, we go to section 216. It says the principal is entitled to claim any benefit that an agent may have gained from a transaction of the agent acted on their own account if the agent acted without the principal's knowledge. Then, whatever secret profits are made by the agent where he has no authority to deal with that, and he does it without the knowledge of the principal, makes a secret profit, then the principal is entitled to recover that secret profit which the agent has made out of the agency business and then make a claim as far as the against the agent is concerned. This is what 216 deals with. Then 217 is an agent may retain uh, out of the sum received on account of the principal in the business of the agency till all money is due to himself in respect of his remuneration is made by and incurred by him and the expenses incurred by him conducting such business and also such remuneration which is payable to him for acting as agent. Suppose, let us say, the agent transacts on his own, makes a profit, then he has got a right of lien. He can retain the money till such time he has been remunerated or he has been compensated or he has been reimbursed by the principal as far as the commission is concerned and as far as the remuneration which is payable to the agent as far as the agency business is concerned. This is the purport of section 217. When 218 is an agent is bound to 218 is an agent is bound to pay his principal all such remuneration on his account. Suppose, let us say, whatever secret profits is made by the agent by acting on his own without the authority of the principal, and then whatever amounts are realized, the agent has to reimburse the principal and pay back that profits which he has earned in respect of the business of agency for and on behalf of the principal. That's what 218 says. Then 219 is an agent is not entitled to payment of this payment for the act until the act is completed, but entitled to receive agreed remuneration or in the absence of agreement to the contra, reasonable remuneration uh, for rendering the services to the principal that are not voluntary or gratuitous on as soon as he completes the task. See, please remember, anyone will pay you only when you carry out the task, only when you carry out the work, only when you finish the tasks which are assigned to you from time to time. Without completing the task, you cannot ask for any remuneration. But as far as the task already completed, reasonable remuneration can be paid by the principal to the agent, subject to the accounts being furnished. And after the accounts are furnished, whatever the agent has to receive, the principal can pay. But please remember one thing, that no payment is payable unless and until the entire task is completed. So, without completing the without completing the task, without completing the work, the agent cannot claim any remuneration. That's what section 2 218 deals with. An agent is bound to pay to the principal all sums received on his account. That's what 218 in the previous section I said. Whatever amounts are received through the transactions by the agent by acting on behalf of the principal and those profits which the agent makes, that has to be repaid back to the principal because it is a business of the principal and not the business of the agent. The next section is 219. So the tasks which are assigned to an agent, the task has to be completed, the work has to be completed in order to be entitled to the remuneration, in order to be entitled for the services rendered. But whatever services he has rendered, to that extent, an agent can be paid by the principal. That is what 219 speaks about. Then, sir, 220. An agent is not entitled to remuneration for any part of the business misconducted. So the question is, if the business is misconducted, it is not done in a proper way, or it is done in an irregular way, or it is done negligently, or it is done without exercise of due diligence, which is expected of a prudent man, then in that case, whatever business is misconducted, the agent is not entitled for remuneration regarding that type of business or that account. Why? Because the question is the business has to be conducted in a proper and a transparent way. So the question is, if it has been misconducted, it has come to the knowledge of the principal that it has been misconducted or that it has been bungled. For that, the agent is not entitled for any remuneration or any reimbursement or any compensation. Then, sir, 221. In the absence of a contract to the contrary, an agent is entitled to retain goods or documents and other property, movable or immobile, until the amount due to him for commission, remuneration, or disbursement has been paid by the principal. By this section 221, it's a special section which says the agent also can exercise the right of lien. Lien means right of detention till such time his he can detain the goods, he can detain the property documents till such time his payment is made, his remuneration is paid, his commission for the services rendered has been paid. Till such time it has been paid by the principal, the agent has got the right of detention, or he can exercise the right of lien and demand the principal, I will release the goods, I will release the properties once my payment is made. Please remember, everyone works for money. Everyone does a job for the other, expecting some remuneration. But if the remuneration is not paid, please remember an agent can detain the goods, be it mobile property or immobile property, till such as by exercising his right of lien, till such time the remuneration or the commission is paid by the principal in respect of the services rendered by the agent. That is what 221 says. 221 says a right of lien is available to an agent for the services rendered, and he has got a right of retaining mobile or immobile property as well as the documents of title belonging to the principal till such time he has been compensated for his remuneration, for his commission, and other things which he has done in the course of the agency business for and on behalf of the principal. Then, sir, we go to Section 222. The employer of an agent is bound to indemnify an agent against all the consequences of all lawful acts done by such agent. The exercise of the authority conferred. Suppose, let us say, 222 says the agent, that is, they say that the employer of the agent is bound to indemnify him against all consequences of all lawful acts done by such agent in the exercise of the agency business under the authority conferred. Suppose the authority is given to the agent to transact the business, conduct the business, act as a conduit pipe, bring about a contractual relationship between the principal and a third party, and he does all those acts. And for all those acts, it is said that the agent is entitled to be indemnified, and if any expenses is incurred for carrying out those transactions, those expenses will have to be reimbursed by the principal to the agent. That is what 222 speaks about. Then, sir, we go to section 223. The employer is required to indemnify an agent against all the acts done by the agent in good faith, though it may cause injury to the rights of third parties. Suppose, let us say, the agent carries out his duties with due diligence and without any negligence, but accidentally some injury is caused to a third party with whom the contract is made, and whatever expenses are incurred for compensating the third party, that money has to be indemnified by the principal to the agent. That's what 223 speaks of. Provided the agent acts in good faith not negligently, not with due prudence he acts, and without any fault on his part. Then, sir, 224, where one person employs another person on his own to do an act which is which is the principal is not liable either upon express or implied where a person employs another person to do an act out of which is criminal. Suppose, let us say, an agent appoints another person to carry out a criminal act. This is not authorized by the agency business, and let us say certain liability arises. Then, in that case, the principal is not liable, not responsible for these acts committed by a third person at the behest of the agent because it has not been done under the authority or permission or sanction of the principal. That's what 223 speaks about. Then, sir, we go to section 224, where one person employs another person to do an act which is criminal, and the principal is not liable either upon the express or implied promise to indemnify the agent. So, this section which I was dealing with, that is what section 224. Suppose, please remember, no principal says do a criminal act, but suppose the agent employs a person, go and hit a person and come. Then, in that case, that person does it, and any criminal liability arises, then it is done without the authority or the principal. And for criminal acts, the principal is not liable, and only the agent is responsible for such acts of a third person who is appointed by him. Then 225 speaks about the principal must make compensation to his agent in respect of uh, any injury caused to the agent by the principal's neglect for want of skill, or let us say, due to the neglect or due to the want of skill on the part of the principal. Any injury is caused, any loss is caused, any damage is caused to the agent, the principal is bound to indemnify, compensate the agent for such injuries. Here, example can be given, sir. A employs as a bricklayer in a building a house and puts up the scaffolding himself, and B is hurt. A must make compensation to B. Please remember, sir, a barber should do his own job. A washerman should do his own trade. A cobbler should do his own trade. Or let us say a lathe machine worker has to do his own trade. But please remember, when you embark upon a trade which you do not know, then the consequences which flow out of it, you will have to compensate the other person who is injured. Here in this case, what happened was A employs B as his contractor to build a house. Once the contract is given to a builder, or once a contract is given to a contractor, it is a job of the contractor to do the job. Let us say here that is house and puts up. Please remember, it is not the job of the owner to put up the scaffolding. Scaffolding means that centering which is put. The question for the purpose of laying the roof. It is the duty of the contractor, but the owner himself puts the scaffolding. The scaffolding means the centering what is called, which is used for the purpose of laying, that collapses and injures the agent. Whatever injury is caused to the agent due to the negligent act of the principal or due to the want of skill on the part of the principal, when it is not his job and the principal does it, then in that case the agent is entitled to be compensated for the injuries that is caused to him. That is what 225 speaks about. Then 226, an act done to an agent may be entered in the same manner. An act done through an agent may be enforced in the same manner and will have the same legal consequences as if the contract has been done by the principal. In the earlier classes itself, I said the liability of the principal and the agent are coextensive with each other. And if any act is done by the agent in the course of the agency business, it is deemed that he has done it in consequence of the authority that is given to him by the principal. and any act or deed which is done by the agent in the course of the agency business duly authorized by the principal and the agent both are jointly and severally liable for such acts. That is what 220. And it's also deemed that it is done by the principal himself personally. For example, most of your advocates, when a general power of attorney or a special power of attorney is executed, in that the last paragraph is generally to do all acts and deeds on my behalf. That's what the principal says. And all acts and deeds done by my attorney shall be ratified by me and shall be binding on me with full effect, and they shall be deemed to be done by me personally. That means whatever authority is given to the agent, whatever powers are given to the agent, if the agent does it, the principal cannot exculpate himself from liability. He, along with the agent, are jointly and severally liable as far as the acts are concerned. And any acts or deeds done by the agent in the course of the agency business within the scope of his authority is binding, and the principal cannot disown the acts, and it is deemed to be that an act done by the principal himself personally. Then, the 228, the principal is not bound to recognize a transaction of an agent during which doing more than they are authorized. Sometimes what happens is an agent over exercises his authority. He does not have authority at all. He does something more than what the authority is given to him under the contract of agency. Then, for all acts which are done by the agent beyond his authority and where he is not authorized, the principal is not liable for such acts of the agent. That's what 228 speaks about. Then, sir, 229. Or any notice given to information obtained by the agent, any given to or information obtained by the agent, provided it be given or obtained in the course of the business transaction by him for the principal, shall between principal and third party the same consequences as if it's been obtained, as if it is obtained by the principal. Given to information obtained by the agent, provided, please remember, notice to an agent is notice to the principal. The third party who gives a notice to an agent is deemed that it also binds the principal, and it's all in the course of the agency business. And for this, and as far as the principal and the agent are concerned, they are jointly liable to the third parties for the transactions. That's what 229 speaks about. Then 230, in the absence of any contract, agent cannot personally enforce contracts entered into by him on behalf of his principal, nor have personally bound by them. That in the absence of a contract to the contrary, an agent cannot personally enforce contract. Please remember, any contract that is entered into by the agent for and on behalf of the principal, the question is the privity of contract comes into play. No doubt, agent is a person who has brought about the contract. Agent is a person who has brought about the contractual relationship, or he has acted as a conduit pipe linking two pipes with a coupling and bringing about a contractual obligation between the principal and a third party. But as far as the enforcement is concerned, he has to join along with the principal and bring an action against the third party, but independently he cannot bring any action. That's what 230 speaks about. Then, sir, 231. If an agent makes a contract with a person who neither knows nor has reason to suspect that he is an agent, the principal may require the performance of the contract, but the other contracting party has against the principal the same rights as he would have had against the agent, and the agent has been the principal. If the principal discloses himself before the contract is completed, the other contracted party may refuse to perform the contract if he can show that he did not know that the agent was not a principal nor who was the principal. Sir, sometimes what happens is, this is very, very common, sir, especially in the building activity. Suppose you ask the agent or a power of attorney holder or a broker, of course, you can't use the word broker, a realtor, saying that who is the owner? Why are you bothered, sir? Anta manade anko. And that you are misled to that aspect. The question is, it is not disclosed to you as to who the owner is. And the broker says he is the owner of the entire property because he has got a GPA in his favor. But the question is, when a contract is entered into a third party, sometimes an agent pretends himself to be the principal himself. The third party also has to make all inquiries. Then what is the duty of the principal, sir? He must say, I am the principal, sir. This man is only an agent. He is not the owner of the property. If he does not do so, then in that case, the third party can refuse to perform the contract unless he comes to know who the actual principal is and who the actual agent is. Are you able to understand, please? Then, sir, 232, where one man makes a contract with another, neither knowing or suspecting that the other is an agent. If the principal requires the performance of the contract, he can only obtain performance subject to the rights and obligations subsisting between the agent and the other party. So the question is, if you want performance, you must make a full disclosure as to who the plaintiff petitioner is, who the principal is and who the agent is. And whenever performance is demanded from a third party, which has been entered into by the agent for and on behalf of the principal, and the agent represents to the third party for all practical purposes, he is the principal. Principal has to clarify the matter and say that he is the principal and the person who has brought about the contract is his agent, and then alone the contract can be enforced. Then 233, rights of a person dealing with an agent personally liable, and rights of a person dealing with the agent personally liable, and a person dealing with them may hold either of them either of the agent or principal liable. Agent of a person dealing with an agent personally liable, uh, liable, and a person dealing with them may hold either of them. Please remember, suppose let us say a person innocently deals with an agent who masquerades himself as the principal and enters into a contract and without disclosing the name of the principal, and the principal also does not disclose that the person who has dealt with them is his agent and not the principal, then in that case, both the principal and the agent can be jointly and severally made responsible for the acts done by the agent. Then we go to section 231. If the agent makes a contract with a person who neither knows or reason to suspect that he is the agent, the principal may require the performance of the contract, but the other contracting party has against the principal the same rights as he would have had against the agent if the agent has been principal. If the principal discloses himself before the contract is completed, the other contracting party may the other contractor may refuse to perform the contract if he comes to know that he did not know that the agent was not a principal and was the principal. So the question is, in order to seek performance, in order to enforce the contract, it is a duty of the principal to clarify the matter to a third party before the contract has started, to say that I am the principal, sir, the agent is only my agent, he is not the principal, and clarify the matter. Then in that case, performance can be enforced and but not otherwise. Then 232 is where there are many where they are where a man makes a contract with another, knowing or to suspect the other as the agent, if the principal requires the performance of the contract, can only obtain performance subject to the rights and obligations subsisting between the agent and other person. So, whenever if the principal is interested to see that the contract is performed in all respects, it is his duty to disclose to the third party, sir, before the contract starts, I am the principal and the other person is my agent. He is not the principal at all, and he is dealing on my behalf for my benefit, and so you have to perform the contract. So the clarification has to be given as to who the principal is and who the agent is. Then 233 is right of a person dealing with an agent personally liable and a person dealing with them may hold either of. Please remember, if an agent acts on himself, deals with a third party, and the principal keeps quiet, does not disclose that he is the principal and this man is only an agent, then in that case, a third party can make both the principal and agent jointly and severally liable for the acts done by them. Then 234 deals with where a person who has made a contract induces the agent to act upon the belief that the principal will only be made liable or induces the principal that the agent only will be liable for cannot enforce cannot afterwards hold liable the agent or principal. Suppose an inducement has been made, that is what is called a fight between two cats and a monkey. The monkey getting benefited because of the quarrel between the two cats. Suppose, let us say, a third party who deals with an agent tells the agent, don't bother, sir, don't tell your principal any contract which you enter into with me, I will only make the principal liable, I will not make you liable. And on the other hand, he tells the principal, don't bother, sir, I will make only the agent liable or responsible. I will leave you scot free in case of any breach or violation. Then, in that case, the question is the third party cannot make either of them liable. Then 235 deals with what is called a person untruly representing himself to be the authorized agent of another, inducing a third person to deal with him or is personally liable. Suppose I told you also, sir, in most of the real estate matters, you go to an agent, the agent says, "It ever boom and anta manajar." Please remember, it is your duty, but though he says don't act on himself, look into the documents to what extent his authority is, what is authority given to him under the power of attorney, whether the entire land is given to him to deal with it or only part of the land. If you don't do it, of course, you got the doctrine of KV tempter, that's a different matter. But here, suppose, let us say, a person represents himself as the to be the authorized agent of another person, inducing the third person to enter into a contract, then the question is the inducement is made, true disclosure is not made, other person is misled, deceit is practiced, fraud is practiced, then in that case, the agent himself is personally liable and the principal can escape his liability. Then we go to section 237. 237 is where an agent without authority has done acts or incurred obligations to third persons on behalf of his principal. Principal is bound by such acts or obligations if he has induced third persons that they are done within agent's authority. Suppose the agent enters into contracts with third parties for and on behalf of the principal and also also assures the third parties that he has got proper authority on behalf of the principal as far as he is concerned, and such acts or obligations are absolutely legal, and the third party acts on that representation, changes his position which he would not have done but for that representation, and the principal does not correct the third party, then in that case, the principal and the agent are both liable jointly and severally. The last section, as far as the law of agency is concerned, is section 238. Misrepresentation or fraud committed by agents acting in the course of the business of third parties has the same effect as done by the principal, but if it is done without authority, the principal is not bound. Here, suppose fraud or misrepresentation is played, or let us say deception is played, a statement is made which is not true, or a statement is made knowing fully well that it is not true, where the other person has been induced to enter into a contract with you, that is the principal in collusion with the agent, does this, both of them are liable, and that's the last section as far as the law of agency is concerned. Here, there's one illustration which will clear the matter. A being B's agent for the sale of goods sale of goods induces C to buy them by misrepresentation, which he was not authorized by B to make. The contract is voidable as between B and C at the option of C. Suppose, let us say, a misrepresentation has been made by an agent, A being B's agent for the sale of goods, induces C. Suppose, let us say, A appoints B as his agent to sell certain goods. Then B induces C to buy them by misrepresentation that he is the owner and he has not and which he was not authorized by B to make the contract. Contract is voidable. So the question is, if any misrepresentation is played, if any fraud has been played, any deception has been practiced by the agent in the course of the agency business, which is not authorized by him to do, the agent himself is liable and he is liable to the third parties. Then the second illustration, sir, that is given is a captain of a ship signs the bills of lading without having received on board the goods mentioned. The bill of lading is void as between B and the pretended consignor. Suppose, let us say, a captain of a ship issues the bills of lading. Bills of lading is the way bill, as they call it, or to take it in the cargo, you require the bill, like something like lorry receipt or railway receipt. It is subject to the goods arriving on board. But before the goods arrive on board, the captain issues the bill of lading. The question is, goods have not yet arrived. Then, in that case, the bills of lading, which has been prepared and issued by the captain, is void because the materials have not reached the board, and that is the reason there is no contract at all. So, this is as far as law of agency is concerned. I think one of the students last time has been asking repeatedly, sir, what are those sections which have been repealed from 239 to 270 or 269? Please remember, those sections are now repealed by Act of 1942. Now, their separate Partnership Act has been formulated. Partnership Act, which was there either in the Contracts Act, has now been made a separate act and they are no longer available in the Contracts Act. That is the reason Section 239 to 269 of the Contracts Act has been repealed and a separate Partnership Act has been formulated. Then in the same way, Section 76 to 123, also that question was asked, that has now been part and parcel of the Sale of Goods Act and it has also been repealed. So, Sale of Goods Act and Partnership Act, which was part and parcel of the Contracts Act, are no longer available in the Contracts Act and are separate enactments governing those laws. So this is as far as the entire Contracts Act is concerned. General contracts as well as specific contracts. General contracts is section 1 to section 75. They are called the general principles of contract, and section 123, 124, 123 to that is 238 is specific contracts. Then specific contracts, we have discussed about indemnity guarantee, then bailment, then pledge and pawn, and then law of agency. Here, the question is, there are different types of agents also, sir. The question is, an agent who is appointed on commission, agent who is liable to be paid commission for the services rendered. Another is called a C and F agent. C and F agent means a person who is the consignee who receives the goods for and on behalf of the consignor, and then all goods will have to be purchased from the C and F agent by the retailers, and he is paid a special commission for conducting this, and he is appointed for specified areas. Then Del Creditor agent. Del Creditor agent is he has given the power of sale, he has given the power of transacting, he is paid a special commission for the services rendered by him. So these are the various facets of the law of agency, and also discuss the law of that is what is called agency by necessity. The questions which linger most of the advocates is, once the principal dies, the agency also dies, the power of attorney also dies. No, sir. If the agent derives an authority or as an authority or as a share in the spoils of the business, or let us say in the property itself, the agency is not destroyed. The question is, as far as this share is concerned, it is kept intact. That is called agency by necessity. So the question is, mostly the commonest example is development agreement come GPA. In that particular case, if the principal dies, the agency does not come to an end, And the agent, if he has got 60% share in the built-up area, who uses his finances, who obtains the clearances, who obtains the permits, who obtains the necessary permissions, etc., he is entitled to reap the fruits of the document which has been executed between him and the owner, and the death of the owner does not vitiate the document, and the document cannot be set aside. That's what we dealt with. So different facets of agency also have discussed. I have also discussed the various facets of bailment. And as far as the pledge and bond, we have discussed it in detail. Indemnity and guarantee also we have discussed it in detail. And the general principles also we have gone in detail. And this is only what is called a nutshell of the entire subject which we have finished. Until now, let me remind you that we have completed 14 subjects as far as the law is concerned. And next time when we assemble, I think we'll be going through the Guardianship Act, and then after that we have got what is called the Hindu Law of Adoptions and Maintenance Act. Then, of course, we have dealt with the different kinds of marriage acts. We will discuss with the Family Courts Act also, and also the question is the, if possible, the Stamps and Registration Act. And last but not the least, we'll discuss the criminal law, what existed earlier, and what are the changes that has been brought about by the latest amendment to both three acts, that is the IPC, CRPC, and the Evidence Act. Please remember, because of paucity of time, because of various other reasons, we could not conduct the Zoom. That's the reason this particular lecture is beamed through the YouTube. We request you to kindly go through it, and the questions, if you have got any doubts, please write down these questions and you can clarify it as and when we assemble for the Zoom class. Thank you very much.